Thank the gentlelady. And now we'd hear from Mr. Morris for 5 minutes.
Thank you, Chair Bono-Mack, and members of the subcommittee. Thank you for inviting the Association of Home Appliance Manufacturers to testify on this important matter. AHAM supports the creation of a public database to assist consumers with easy access to relevant and accurate safety information, and it's important that that situation be properly funded. Of course, there are many private internet sites that play the same role, and so it makes little sense for the Commission to expend major resources to create a competing website unless it adds value. A critical part of that value proposition is that the information should be of high quality, accuracy, and utility. Unfortunately, the Commission's current database design hinders the publication of accurate information. It places unreasonable burden on manufacturer, and it does not require timely resolution of good faith material inaccuracy claims. We need the database to be news we can use. With a few changes, the accuracy of the information can be improved. Nothing we're proposing inhibits in any way the Commission from pursuing reports it receives from consumers or anyone else to see if a corrective action is necessary or a violation of the standards has occurred. Our testimony here is limited to what is placed on a public, incident, internet-based database. We have 3 points. 1, the Commission should resolve claims of material inaccuracy. According to the CPSC, material inaccurate information is a report of harm in a report which contains, quote, information that is false and misleading and which is so substantial and important as to affect a reasonable consumer's decision-making about the product, unquote. This includes misidentification of the product, manufacturer or private labeler, or the harm or risk of harm. The manufacturer has a burden of proof and must provide specific evidence and describe how the report is wrong and how it should be corrected. It's in every legitimate party's interest that the Commission post only accurate information to the database. Under the current regulations, all harm reports, except for the ones of outstanding confidentiality claims, have to be posted to the database within 10 days of transmitting the report to the company, no matter what. Accordingly, even if a company meets the Commission's burden of proof and responds within the short 10-day period by submitting substantial evidence of material inaccuracy, the Commission will post the complaint to the database before resolving the material inaccuracy claim. The Commission actually has no obligation to resolve the material inaccuracy claim by any particular time. As we all know, once information has been published on the Internet, even if it's revised or retracted later, it stays in cyberspace forever and may already have done damage. We believe it's wrong for the federal government to allow companies and their brands to be unfairly characterized, even slandered, without evaluating a company's claim. Because of the extremely limited time frame to receive the information, analyze it, and develop a response, we believe it's unlikely that many companies will comment on a high percentage of the reports of harm, and the chairman spoke earlier of the soft launch proving what we say. If a company does respond, basic fairness requires that the government decide before the data is publicly released. 2, the eligible reporters to the database should be limited to those with direct information. The CPSIA lists those who may submit reports of harm to the inclusion of the public incident database. The congressional specificity of these groups was purposeful to encourage their involvement and to make clear that those who are not the consumers, their representatives, first responders, or care providers to consumers should not participate in the database for their own ends. This applies to trial lawyers, consumer groups, and even trade associations like mine. Remarkably, the Commission is now in the final database rule shoehorned certain non-governmental organizations into a definition of public safety entity. Congress should reinstate the original intent of the legislation. The database ought to be limited to those people who purchased the product, used the product, or cared for someone who has suffered an injury. Otherwise, the database is simply a blog, and there's no reason for the federal government to displace or compete with private blogs. 3, the Commission should require registration of model or other descriptive information. There are thousands of categories of consumer products, manufacturers and brands, where there are numerous models of a product. Although the Commission encourages submitters to provide more detailed information, which will allow the public and manufacturers to identify which particular product was subject to alleged incident, it does not require that information. This is a mistake which Congress should remedy. The suggestions that we've made do not prevent a useful, accessible public database. Rather, we believe our proposals enhance the utility of this new mechanism. Thank you for the opportunity to testify and be glad to answer questions. Thank you.